Dumelang! Welcome to my channel, Botswana Thinking Law, where I bring you and the law closer. But before we get started in this video, I'd like to put in a disclaimer. This is not legal advice. This is simply a sharing of general information. If you have a problem of a legal nature, please engage the services of an attorney. Now back to our video. This is the last and final part, being part 2 in relation to the law in dealing with children. And when we pick up from part 1, we will be talking about the remaining topics on the law in relation to children out of the 6 that had been outlined in part 1. Paternity of a child. In terms of the law, within 60 days of a child being born, then the details have to be given in relation to the parentage of that child. And this is for purposes of the registration of the birth of the child. The mother is then required to give the details of the father of this child. And if the mother does not give those details and does not have a good reason for not giving those details, then they are likely to be sued by the government and they face jail time or even a fine. This puts a lot of mothers in an uncomfortable situation, in that the law seems to be forcing them to pick between Thabo, Obakeng, Mpho, to say who among these people is the father of the child. Sometimes she really does not know, but because they feel pressured, or sometimes because they see that one of them has more money, they will then say, no, it is Mpho. Mpho is the father of their child. The problem now becomes, if she says Mpho is the father of the child, then Mpho has to come and sign the necessary documents to say he is the father of the child. If he refuses to sign the documents and says he is not the father of the child, then Mpho has to pay for a paternity test. If Mpho cannot afford to pay for the paternity test, then his name will be written on the birth certificate as the father. I want to repeat that. If Mpho does not pay for the paternity test, and it doesn't matter what the reason for the failure is, if maybe they don't have money, maybe they forget, any number of reasons. If they do not pay for that paternity test, the law says their name will, or his name will be recorded in the birth certificate as the father of that child. This creates a very difficult situation because there is nothing that the mother has given to show that Mpho is the father of the child. And if a person is poor and cannot afford to pay for a paternity test, which I understand is from around 3,000, 3.5 or more, then now they are forced to take care of this child and they are recorded as the father of the child, even though there is not one single proof that this person is the father. And the law in Botswana has said this is because when you look at the situation, we use a principle that says if a person has ever had contact with a woman of a sexual nature, that they slept together, then they are considered to be the father unless they can show differently, or unless the situation shows that it could not be possible. An example is maybe this man sleeps with a woman and she's 24 years old and they break up. And then in 7 years' time, she's pregnant and says, no, that man is the one who is the father of the child. If the man goes to court and says, I cannot possibly be the father of this child because the last time I was with this woman in this type of situation was 7 years ago, how could I possibly be the father of this child? Sometimes, unfortunately, because of the economic situation of the mother and the father, she will say that someone is the father because he has more money, not necessarily a lot of money. More money could be subjective. If you look at the three men and you find that one earns 100 pula, the other 500, the other 1.5, women sometimes will say it's the one who earns 1.5 because they know that the maintenance that is going to go to the child might be higher. I am giving this as an example. Please understand that point. If that is the situation, just because someone earns 1,500, it doesn't mean that they can afford a paternity test worth 3,000 or 3.5. And then 10 years down the line, now this person earns 10,000 pula because of various things in life. And they decide, I'm going to then do a paternity test now because when I look at this child looks nothing like me. This child doesn't look like anyone in my family, nothing. They then go and do a paternity test and it is found out that he is not the father of this child. What then happens is that the relationship between the father and the child that has been created doesn't actually exist in law. This man can go to court to have his name removed from the birth certificate. This man can actually decide, I am no longer going to look after this child. I am no longer going to spend time with this child. And he will have the right to sue the mother for all the maintenance that he has been providing for this child all of these years. Yes, there are instances where the law says after, I think it's about 4 or 6 years, without you contesting paternity, then you cannot come back. However, there is reasonable argument to say, but if this person is not my child, and I have a DNA test here to show that this person is not my child, why should I be forced to continue as a parent of this child? Particularly because as human beings, you might start off and say, I've been looking after this person all these years. I want to continue. I'll treat them as my child. And then 2 months down the line, you decide, Ipile, that woman was lying to me. I can't do this anymore. And because of that, things have a ripple effect. And therefore, the fact that people are then forced onto birth certificates might not be the best situation. It is, however, still the law. As soon as your name is on the birth certificate, then a person can sue you for maintenance and so on and so forth. But remember, you can also sue for custody and access. You can say, I want to live with my child, and you'll be the one to pay maintenance and give good reasons for why. The problem becomes if you've been living with this child for 10 years and you are later shown not to be the father. And sometimes it could be issues where the child is hospitalized and they need blood donation and tests are done, and somehow it comes out that this person is not the father. It doesn't necessarily have to be a deliberate situation where this man will then go for a DNA test. There are certain tests that might be done as part of processes at a hospital that might reveal this particular situation. And for that reason, it is always advisable that when people are able to, and if they want to, they should find a way to be able to have a paternity test done. And it shouldn't be done with the spirit of saying, oh, you've been cheating on me. Sometimes if a person doesn't have any doubt, then they can decide not to do a paternity test. But if there's something at the back of your mind that says to you, there's a possibility this might not be my child, then it is always best to do a paternity test. This is not always a situation that happens where people are not married. Even people that are married, there are always situations or instances where people find out later that the child born in the marriage is not the child of the husband. And the child, when born in a marriage, automatically the name of the father recorded on the birth certificate is that of the husband. If the situation then arises where it is shown that the husband is actually not the father, then the consequences also have the same ripple effect and might even lead to a divorce. So people have to decide on a situation by situation basis on what it is that works best for them. When it comes to capacity of a child to sue or be sued or to enter into contracts and so on, I would like to refer you to my video where I talk about capacity of various individuals. And when I say individuals, I'm talking about natural persons, companies, different entities, because in that video, I go into detail about what a child can do, at what age they can do it, and so on and so forth when it comes to issues of suing and being sued, entering into contracts, and so on. And if you watch that video, it will have timestamps to lead you to specific portions, and you can skip to the portion that deals with capacity of a child to sue or be sued or enter into contracts. The next point is adoption. Adoptions are made in terms of the Adoption Act. And if you look at the Adoption Act, if an adoption is not made in terms of that law, then the adoption is not recognized. However, there have been cases where there has been a customary law adoption that has been recognized by the law. However, if you look at the Adoption Act, it does not include customary law adoptions. This means that if an adoption is under customary law and a person is claiming that they were adopted under customary law or that they adopted a child under customary law, they have to prove to any court what the adoption process is under that particular customary law and to demonstrate that the adoption did indeed take place under customary law. Now, this became an issue when I posted on my Twitter at BW Thinking Law on the issue of adoption. And some people raised the issue that, when people get married, where a mother who has a child who is born out of wedlock marries someone else who is not the father, then at the patlo or the marriage and so on, they are then asked, meaning you are taking her with her child. And the prospective husband then says yes, and they say that is an adoption. That might or might not be an adoption, depending on what the customary law of that particular group is. Some groups might say in order for an adoption to be valid in customary law, it has to be done where a person will go to the parents of the woman who has the child and then actually pay what is called marries for the child. And when they do that, then the child is considered to be adopted, or they might have to go to the kota, and so on and so forth. So just simply asking the question, meaning you're taking her with her child or children, doesn't necessarily mean that this is a customary law adoption. This adoption has to be something that is proven as a fact, and there has to be the customary law of that particular group that demonstrates that the adoption takes place. So it might or it might not be a customary law adoption. And the reason why this is necessary to discuss is to recognize that the system of law in Botswana differs. You have the customary law, and then you have the common or civil law. That was the law that is created in terms of written acts of parliament. Now, when it comes to written acts of parliament, the Adoption Act only seems to recognize adoptions made through that particular act and the steps taken inside that act being followed. And one of the steps to be taken, and let's continue with this example of where a woman has a child, she was never married to the father of this child, she's getting married to someone else, and she's talked to this person and she's decided, or they've decided, that this new man or this prospective husband or the husband at the time should adopt the child. Then an application has to be made to the court seeking an adoption order. And what the adoption order does is it takes away the rights of the parent and the duties of the parent that was actually the biological parent of the child. It can also happen if the father is the one that has the child and marries another woman and wants that woman to be the one to adopt the child, and he and her become the recognized legal parents of this child. Where such an adoption happens, then the father of the child, who is being stripped of all of these parental rights and duties, has to consent to the adoption, one, or be allowed to oppose the adoption. If the adoption application is brought, inside, the person, being the mother or father who is for the adoption, has to give reasons why the adoption has to take place. And because of how severe the implications of adoptions are, the courts are very slow to grant adoption orders, because an adoption order cuts the relationship between the biological parent and the child and creates a new relationship between the adoptive parent and the child, such that if a child is adopted by two completely different people, neither the biological mother nor the biological father are keeping their parental rights, then these two people, or either one of them, cannot come back 10 years later and say, I want to see my child. They cannot come back 10 years later and say, this is my child. Because in terms of the law, as soon as the adoption was done and the necessary period has passed for it to be confirmed, then it cannot be reversed. And this parent does not have any rights or duties towards the child. And the child can also not come back and say, I want maintenance from my biological parents, because the biological parents are no longer recognized under the law as the parents of that child. However, once a person adopts a child, then all the rights and duties that any parent biologically has in respect of the child will then attach to that person. An example, when we continue with this mother who marries a person and he adopts this woman's child, if the marriage does not work out and they get divorced, this man cannot walk away and say, I was only adopting this child because I was marrying the child's mother. No. This man has a right and a duty to maintain this child and have access or custody of the child. Meaning you as the biological mother has the ability to lose custody of a child. If during the divorce this man is able to prove no, this child would be better off staying with me, he can be given custody of the child to live day to day with that child, and the biological mother only having access and paying maintenance for that child. This man also cannot walk away. He can be sued for maintenance by the mother of this child even after the divorce, because an adoption is not necessarily based on the marriage. The adoption creates a parent and child relationship between the adopted child and the adoptive parent. The next issue would be inheritance. In terms of the Children's Act, a child is entitled to inherit from their parent. And this inheritance is premised on the fact that this child is still a minor, because the Children's Act, when it says a child, it means a person below the age of 18. However, if a parent does not leave anything to a minor child in a will, this will is open to challenge through the Children's Act to say, but in terms of the law, this child is entitled to inherit, or at the very least is entitled to maintenance from the estate of the deceased parent if the parent has passed away at the time of the challenge. If the child is older than the age of 18 but has not become self-supporting, maybe they're at school and the parent has been looking after them, then this child can sue the estate of the parent for maintenance or support, even if there is a will that leaves nothing to this child, because the duty of support is always in existence as long as this child is one, either a minor, or if they are major, they are not self-supporting and they can demonstrate that this parent who has passed away was supporting them and was going to support them until they finished their studies. Another point to consider, especially in Botswana, is that most of the time you find that a child who is around 18 or 19 is still in secondary school. They're either doing Form 4 or Form 5, or just finished and they're waiting to find out if they'll be going to higher learning. And in that particular instance, if this person has been maintaining this child, then the maintenance has to continue until such a point where the child can become self-supporting, or if they're not self-supporting, until it can be reasonably argued that they should no longer be getting maintenance. This duty of support of a child exists whether or not this person is married to someone else. An example is where maybe a mother had a child with one man, and this child is living with that man and she's married to someone else, and she has children in the marriage and so on. Just because she's married to someone else or has children in that marriage, it doesn't take away the fact that she has to look after this other child that she had as well. This is also true for the father as well. If he's married to someone else, has children in that marriage, it doesn't take away that he still has to look after this other child that they had before they married someone else. And sometimes in law it is easier and it is the situation that children automatically inherit from their mothers. But that is not always the situation when it comes to fathers. And this is because when a child is born outside of a marriage, the law only looks at the maintenance aspect, but not the automatic inheritance that exists in relation to a mother. And therefore, fathers should put in a will anything that they want to leave to their child who is born outside of a marriage in order to avoid any issues. If you want a more in-depth discussion on this issue of inheritance, I have a video that I've created where I talk about estate planning and so on. In it, I go into more detail about inheritance, where a person leaves a will, where a person doesn't leave a will, if that person is a man or a woman, if children are born inside of a marriage, and what their rights are in relation to their mothers and in relation to their fathers and so on. So it goes into more detail than this particular discussion on inheritance, and it tells you about the divisions of inheritance in relation to children and parents and so on. And it must be noted that in that discussion, it is clear that if there is no will and there are children that are born in a marriage, then those children are entitled to automatically inherit from their parents. It does not matter whether those children are below or above the age of 18. If they are born inside a marriage and one of the parents dies, let's say the father passes away, then the children together with the mother have an automatic right of inheritance. If the mother passes away and there is no will and the father is left, then those children have an automatic right of inheritance. I know there was some time back where there was a video circulating where some officer had said, these things belong to the parents and therefore the children don't have a right to inherit if one of them passes away. And these children were born in this marriage. That is not the law. The law says if there is no will and the children are born with a woman, there is automatic right of inheritance. With a man, it is only if the children are born of his marriage that there is an automatic right. If they are not born in the marriage, then there is something that can be reasonably argued to say they can inherit if there are certain things that can be demonstrated. Right now, the law is still not clear on what position it will take to say, are we going to look past the law that says a child born out of wedlock cannot automatically inherit from their father because this is discrimination based on gender? Or are we going to continue this archaic and old-fashioned situation of the law that clearly has been surpassed or passed by time? But please, for a better and in-depth understanding, go and watch that video for more and better understanding. And in situations where, let's say, a child is born in a marriage and the parents get divorced, right? After the parents get divorced, then the father decides to remarry. And this is a situation I've heard of a lot, especially in Botswana culture. The children will then say to the father, give us our inheritance before you marry this woman. None of these children's parents have passed away. The division of the property was done as a result of a divorce. And these children are asking their parents for inheritance while they are still alive because they want to marry someone else. That is not the law. No parent has a duty to give any child any inheritance as long as that parent is alive. The difference is where the marriage comes to an end, not because the people get divorced, but because of death. If there was no will, like I said, yes. If this parent wants to remarry, then the children can say, give us our share of the estate of the parent who passed away. But if it was a divorce and this person wants to remarry and children say they want their inheritance, no. That is not in accordance with the law, and any parent can say to those children, you are entitled to nothing. And in fact, I'm writing a will right now to leave everything to a charity. As long as, remember, those children are not below the age of 18. If they are below the age of 18, then the inheritance aspect in the Children's Act comes into play and the support aspect. But any child who says, give me the inheritance, is usually above the age of even 25. And therefore, they are entitled to nothing. Whatever inheritance they get, if you don't have a will, they only get when you pass away. If you have a will, you can leave it to someone completely different. And having said that, thank you for joining me. I hope you really enjoyed this video. I hope it was informative to you. Please like, share, subscribe, ring the notification bell so that every time I put up a video, you get notified. Follow me on my Twitter at BW Thinking Law. Follow me on my Facebook page, Botswana Thinking Law. And as well, people can put in suggestions of the videos they want me to do. You can put them in the comments down below. You can put other video suggestions on my Twitter or on my Facebook. I'm always happy for engagement with you guys. And I'm happy you joined me today. Bye!